Hello, everybody. I'm having this, you see like the light coming right across my face. Exactly. I wasn't doing this while we were talking in the green room. And then now the sun is just past the tree outside my office window. So I will effort finding the right spot so that I do not look like, I don't know, like a Halloween extra here. But thank you for joining us here today to have this conversation about trade secrets. Our numbers are growing. I'll give you all a minute to come in and find your seat. It feels that that's the way that Zoom has this happen, right, Renee? I mean,
Yeah.
You don't click start and then everybody in the waiting room comes in all at once. It's like you go in single file and you're finding your seat. So it looks like we're kind of plateauing at the minute. I'm sure we'll have more people join us over the first 5 to 10 minutes, as we always do. But want to thank you here for joining us today for this important conversation about protecting and identifying trade secret assets and turning really what is confidential into something that is monetizable and something that you can record and capture. So, Renee, why don't we just introduce the panelists? So go for it.
All right. So we're going to start with James Pooley. He is one of the world's foremost experts in trade secret law and management. His treatise, Trade Secrets, updated semi-annually, is the leading lawyer's desk reference on the subject. His career as a sought-after advisor, IP litigator, and information security expert spans over 50 years. He has served as Deputy Director General of the World Intellectual Property Organization in Geneva from 2009 to 2014, as well as President of the AIPLA and Chairman of the National Inventors Hall of Fame. Jim currently runs a private law practice in Silicon Valley where he specializes in litigation strategy, expert witnessing, and information security counseling. Next, we have Ray Miller. He is a partner and U.S. chair of the Life Sciences Patent Development and Strategy Department at DLA Piper, where he helps clients identify, protect, secure, and optimize the value of their IP by combining strategic patent prosecution with manufacturing and regulatory exclusivity strategies, and manages freedom to operate manufacturing and supply considerations. His clients include private equity and venture capital funds, pharmaceutical and biotechnology firms, world-class medical and research facilities, and Fortune 500 companies with well-developed IP portfolios. Next, we have Dr. Tim Londergan. He is a serial entrepreneur who is passionate about technology, IP, and innovative business models. He is the CEO and founder of Tangibly, which is the world's first enterprise SaaS for trade secret management tool. Previously, Tim was a portfolio manager and head of commercial development at Intellectual Ventures, where he led investments in chemicals, IoT, and material sciences, and has founded and co-founded several companies over the years. Tim has a PhD in organic chemistry from the University of Southern California, and he holds more than 50 patents and applications. He's also published peer-reviewed articles on topics including synthetic chemistry, recycling and carbon credit systems, optical materials, and biosensing. And last but not least, we have our moderator, Gene Quinn. He is a patent attorney and a leading commenter on patent law and innovation policy. He founded IPWatchdog in 1999, 25 years next year. And since he has twice been named one of the top 50 most influential people in IP and has repeatedly been recognized as one of the top IP strategists in the world. So you are in great hands with this panel. Back to you, Gene.
Good, great, thank you. And I have a feeling I'm going to be dodging the sunshine here. And it's interesting that we're talking about trade secrets today, right? Because this is extremely valuable business information. And obviously it was a secret to me that that if we had this an hour later than normal, that I would be fighting the sun and trajectory of the sun through the lights. So, the information that is valuable and not known and unidentified, it's out there all the time. And sometimes it can be something as simple as I didn't anticipate the light coming through my window, and this is going to maybe be a little bit of annoyance for more for me than for you guys. Or it could be something that you really don't know that you have that is extremely valuable to others that you can monetize in a number of ways, whether it's through licensing and know-how or whether it's just through you have better insight of your customers, so you can give them a little bit more of what they're looking for. So there's a lot here. Want to let you know, feel free to send us your questions. For these types of webinars, particularly with trade secrets, we usually get a lot of questions. We're going to try and answer as many of your questions as we possibly can. I'll be monitoring the questions as we go along. But gentlemen, I'd like to just kick it to you to give us your preliminary thoughts, and we can go in the order in which Renee introduced you. Where do you want to start? Where do you want the audience to be thinking about trade secrets and circa 2023? Jim, let's begin with you.
Yeah, thanks, Gene, and thanks, Renee. The main message I'd like to leave is that traditionally we've looked at trade secrets, and to the extent we've paid attention to them at all, from a defensive posture. In other words, it's always been about keeping the information inside the company. How do we protect against loss? How do we protect against contamination? And those are important things. But if we're going to get full value from this asset, we need to be thinking about how to monetize and commercialize it so that it contributes to enterprise value.
Yeah, absolutely. Ray, your initial thoughts here.
Yeah, Gene, I appreciate you inviting me to be on the panel. From my perspective, I view it as sort of a natural balancing act to patents. So, you see this pendulum swinging where, patent enforcement was, the only way to go for a long period of time, and really always thinking about the success and how we're going to get a patent, as opposed to being holistic and looking at the value of the trade secrets. So the message I want to send is, it's not always in the successes. I think the value of negative know-how, as an example, has, an increased importance to the success of companies. And I think it's all about, education, awareness, and frankly, documenting and treating it like an asset.
Yeah. Because if you don't treat it like one, it's not. So when people, I always laugh, when people say, I've heard tech company CEOs and even GCs who should know better say, oh, we don't have any trade secrets. I chuckle because they're probably right. Not that they couldn't have had any trade secrets, but you're right. You don't have any trade secrets because you didn't care.
Right.
So, all right, great. Thanks a lot, Ray. And Tim, last but certainly not least, your initial thoughts.
Yeah. So, in the last 3 years, since we started Tangibly, the conversation around trade secrets has absolutely dramatically improved, increased. You see it a lot more all over. And with that, you actually also see a wide diversity of views on what is right. And I think Jim will touch on some of this at some point today. And I think there's going to be a convergence over the next 5 years on what is more right than wrong. And so I think knowing that there's this sort of fluidity out there right now, I think my main message is just do something. So.
Right. Because, if you're not doing anything, there's no way that that's reasonable.
100%.
Yeah. And maybe
yes.
I'm gonna go out of turn here, because I just thought this was the greatest slide. We all had a great chuckle here. Is hope is not a trade secret strategy. I think my opening here, and this is Tim's slide, and I am sorry to steal your thunder, and we'll come back to it in due course in order. But if I had an opening statement here, it would be hope is a town in Arkansas. It is not a trade secret strategy, So with that, gentlemen, thank you for your thoughts. And I know Jim, you've got a couple slides you've prepared for us, and then Tim's got some.
And actually, it very much relates to what the point you just brought up, because, Gene, the perspective is everything here. And we have to be honest and recognize that as an IP community over the year, we, particularly the lawyers among us, have tended to view trade secrets in kind of a doctrinal way and really separate it basically from the real IP, the registered rights. Trade secrets always seemed so mysterious. They're a matter of state law, but what law we don't know. You have to go to state court to do something about it. And so we tend to push it off to the side and ignore it, and use the excuse of best mode to just say, okay, anything we have related to the invention that we're patenting, we're going to throw into the application. But this is not how our clients view the world of the information that matters to them. So let's look at the other slide and appreciate, flip to the next slide, and appreciate the perspective that our clients have. They don't see it as legal doctrine issues. They see this as assets and liabilities, things that they're worried about, they need to be protected from, and things that they want to leverage for the success of the enterprise. And so it really helps us as we're trying to help our clients manage this area to be thinking the same way that they do.
Yeah, no doubt. Ray, your thoughts on this? I mean, what do you tell clients?
This is really interesting to me because I think what Jim points out is that it's not even clear which legal department within an organization or within a firm should be handling the trade secrets. Clearly you have sort of the employment law aspects and you have trade secrets that aren't technical, and they can have every bit as much importance as a technical trade secret. So I think why you see this dystopia is because you have different departments who are taking ownership of the trade secrets. From my perspective, when Tim and I started talking about Tangibly years ago, and was really how do you use that to balance the patent portfolio. But I certainly recognize that the employment lawyers are out there thinking about it a different way. They're thinking about how do I deal with employees that are departing. So and I think turning to Jim's second slide, which is really about sort of asset management, what I've seen over the last 2 or 3 years is a real focus on and a drill down on the trade secret. And if I'm able to articulate it, venture capital and partners are able to value it. So as opposed to answering the due diligence question, do you have any trade secrets? Of course we do. And then tell me what they are, and they have no idea. I'm now able to roll out a privilege log that shows the trade secrets identified and categorized.
Right. I mean, and that makes a huge difference. Tim, do you while I'm going to ask you to comment on this as well. I'm going to launch a poll question here for the audience as well while we get your thoughts to get their general sense on trade secret protection and is it important as patents, not as important, etc. But go ahead, Tim, your thoughts.
Well, I just learned that panelists can't vote, so darn it, I'm not going to be able to skew the data in my favor.
Yeah.
I'm hearing Ray's point about venture. So I got a great sort of screenshot from one of our investors who said, "Hey, I just got this pitch deck," and it was literally just a screenshot of the intellectual property slide. It was a sophisticated company, and it's like 83 patent families or something like that, and then it said 247 trade secrets. And so I was like, holy cow, I mean, like, it's happening, right? So the fact that there are now tech companies they're going to their venture investors and having the number of trade secrets articulated, I thought, wow, that's it's not every deck that has that, certainly, but the fact that one does, I think it's a great leading indicator, if nothing else. So
and if you want an extreme example, everybody look at what TSMC has done. I mean, they're like world-class effort on putting together a program which they started about 10 years ago, and because the fellow who put it together and has been running it, Fortune Shih, has such great energy and creativity, they've managed to get 40,000 disclosures from their engineers about various innovations that will help in the business, to the point where now they're developing AI tools to mine that data to discover where the centers of innovation and excellence are within the company. And it's just extraordinary what they've been able to do. But it started with identifying and culling out from the people who are holding on to it, all these innovations in a way that they could track them. I should point out that this is the idea of identifying your trade secrets at some level of granularity is a controversial one, right? This is there's a lot of people who express concern, properly so, because of potential litigation and what happens if you miss something, what happens if you focus on a certain area and not on others that become important later. Well, these things, are issues that can be managed, but you can't do anything with these assets if you don't have at least some idea of what they are.
Right. If you don't know what they are, you can't leverage them yourselves, and you certainly can't license them or include them in a license. I mean, the patent is nice. It's very nice, but most often in my experience, it's all of the stuff that goes around the patent that's not in the patent that's extremely valuable. Ray, I see you shaking your head, and you have a life sciences background, right? I mean, you could talk, and that area, perhaps even more so than any other area, the trade secrets are really extremely valuable.
That's right. And I mean, if you think about sort of, tiered royalties in a license agreement based on sort of the end of the natural patent term, but still go on while you have exclusivity, because that exclusivity is being created by your trade secrets and your know-how. So that is an immediate recognition of the value of your trade secrets. And if you're an acquirer, you also want to know what you're acquiring, right? So you want to know which employees are tied to it. And I have a pretty strong view on the collection and articulation of the asset. I've heard the litigator approach that you're not going to know what's important until it's important. Well, you can't evaluate anything unless you sort of capture, educate, and memorialize. So, at the end of the day, most of the misappropriation that goes on in trade secret is, a rapid rush to an injunction. If you can't articulate what it is that you're trying to prevent from getting out on the market, then good luck with that injunction, right?
Right. And if you're not prepared, good luck, right? I mean, I get the view that you're not going to know until you know. But the problem in our space, and this is true for patents, and it's even more true for trade secrets, is by the time you know, if you didn't do anything, it's too late.
Right.
I mean, Jim, go ahead.
Look, the courts expect you to be doing something.
Anything.
And that's what they call reasonable efforts. It's a ticket to entry in the courtroom for trade secret cases. If you've been asleep at the wheel on this, they can basically declare you don't have any trade secrets, and they expect you to have an informed approach, something where you have a policy, you have training systems, you have onboarding and exiting procedures and so forth that basically start with understanding what you have, so that you know what you need to do in training the workforce, in dealing with third parties and all the rest of it. That's where it all starts.
Yeah, Jim, and I actually think the capture aspect of it is critical, but you touched on it, the education component, like educating your workforce on what we do consider trade secrets. And it doesn't have to be a technical advancement. It could be a customer list. There's a variety of, it could be the sunlight coming in Jean's window. I mean, there's all kinds of things out there, but educating people. And I think they take pride in that ownership. And we've seen it, Tim, and the example you gave where 237 trade secrets, we've seen people in organizations start to recognize, wait a second, we are an intellectual capital organization. Just because we don't have 73 patents doesn't mean that we're not built on intellectual capital.
Mm-hmm. Yeah, no, absolutely. Let's get the poll results out here and then get you guys to take a look. I mean, we had 65%, the greatest number, and this was multiple choice, so this is going to add up to over 100. You could have picked multiple answers. It's a great way to protect my asset for a length of years. I mean, that's certainly, I would think everybody would have to, that's not shocking that got a lot of protection, right? Because as we talked about with the licensing agreements, your trade secret license, if your licensing agreement is written properly, outlives and can significantly outlive the life of the patent. Oh, it's got to be written properly and that sort of thing. But, you know, trade secrets are extremely valuable, more valuable than patents, almost a quarter of people. Not as important as patents. It's got the smallest number of votes. And then also about a quarter, it's complex, expensive, and time consuming. Jim, I see you look a little surprised at that. I don't know that I would have picked that. I don't think it's complex. It's
complex, expensive, and that represents one of those ungrounded fears that people have. You know, the appropriate way to approach trade secret protection is always contextual with the business and the business's needs and the threat environment that they're in. The great thing about this is it's pretty easy, and it doesn't take a lot of investment in management time and assets and so forth to get people around the table, talk about what is it that you are concerned about losing and keeping control over. What do you lose sleep at night about? Everybody then develops an understanding of the sorts of things that we need to protect. From there, as long as you have a person who's going to be the champion of this process, it's an easy thing to put in. We're very used to doing this in business. We call it risk management. It's done in a lot of different areas. Yeah. So it can be done in a way that absolutely fits with the environment of the company that you're in. So I understand people have a feeling, and maybe it's because they think that trade secrets have to be inventoried down to the most granular level, and we can't afford to shut down the place while we do that. We don't need to do that kind of approach. That's not what's required.
Yeah. So Tim, what are your reactions to the responses here? Were these what you expected? Anything jump out at you?
It's interesting. There's been a few studies, some of the big consulting firms, where there's a lot of people are now sort of saying that their trade secrets are more valuable than patents. So I would have guessed that one would have gotten a little bit more. But Jim's right on the money. It's funny, we built a little bit of just real simple frameworks to help people understand, like, this isn't that hard. Dedicate a couple days and you're at the 90% line, right? And so when you sort of get down to the guts of it, whether it's a project in a big company or a business unit, or whether it's a 200 or 300 person life sciences company, be surprised once you just sort of have the conversation, going and tackling that initial, what we'll call a high value list of trade secrets. It's not much work, because there's probably about 5 to 10 people in the company that need to be around the table to at least get some sort of high level descriptors sort of in place. So,
yeah, Gene, one of the I've seen is it's not either or, right? It's patents and trade secrets and employment agreements and contractual agreements that restrict people. Too often I see organizations sort of saying, we're gonna abandon our patent portfolio and just focus on trade secrets. Well, that's got all kinds of problems associated.
Right.
Right. It's got to be a real balance.
Yeah, it really does. And we have a question I saw in the chat about how do you achieve that proper balance. I mean, I would suggest that particularly in the U.S., trade secrets are, or either they are right now or are becoming more valuable than patents. And obviously it depends upon whether you and your company have done enough to document what you have and then protect what you have. And we're going to get to that here in a minute. But what's the right balance, Ray?
Yeah, I mean, I think it's interrogating trade secret to decide whether people can easily reverse engineer is always sort of the first tool I go to when I'm trying to balance, because, regardless of how good the trade secret is, regardless of how it advances, a client's asset, if somebody can easily reverse engineer and they're not exposed to the sort of the confidential relationship, the trade secret's not useful against that person. So I think, the first test for me is the ability for somebody to pick it up, and tell what the trade secret is. Because if that's the case, let's go to the patent office and get appropriate patent protection.
Right, right. And remember, even if you're getting patent protection, there's never been a duty to update your filing the day after if you make a big discovery that influences it. And if you protect it properly, that's a trade secret. And you could have both. I mean, that's the thing a lot of people don't understand. Patents and trademarks, or trade secrets rather, work perfectly together. So many people are mistaken when they think you go the patent route, you have foreclosed the trade secret route. No, not at all. You are really opening up a trade secret route, because if it's valuable enough to patent, it ought to be valuable enough to pursue for a while. And as you're pursuing it for a while, you're going to learn way more than you knew at the time of filing the patent.
Yeah.
So,
and
right.
one of the things I wanted to sort of stress is people within organizations understand secrets, right? We've been dealing with secrets since we've been a kid. Not everybody understands patents and the limitations that patent claims have. And even very sophisticated clients still struggle with concepts, of patent limitations and claim limitations. But they can easily understand a trade secret, right? They know that it's associated with them. Nobody knows it, and it gives them some value.
And yet we have this problem of trying to get management to understand and allocate resources to the effort. We have the termite problem. There's something eating away at the foundation. There's these assets are being lost by failure to pay attention to them, but it's not apparent to everybody. And so we need to find a way to get beyond that and help management understand that, as we were talking about before, this doesn't take a lot of effort to get to the point, like Tim said, where you're 90% of the way there. It takes a very, very small investment of time, but we have to get their attention focused on it. I mean, one way is to remind everybody that all patents start out as trade secrets. And if we don't have a program in place that adequately trains the workforce and sets up the frameworks for protecting this kind of stuff, then we're going to lose things along the way.
Yeah. So let me, I hate to cut this short, but we're getting some questions in the chat and in the Q&A box that I think are going to be answered by this next slide, Tim, that you have together. So why now? I mean, we have some people saying, well, aren't trade secrets a state-by-state issue? And then we had another question about whether what I was saying is that trade secrets are becoming more valuable because of the way, for example, the courts are handling 101. And I think that that's certainly, a part of it, not the only part of it. For me, it's that, but it's also, and I had this conversation just last night with someone, and the Federal Circuit is not yet ready to uphold $1 billion verdict. They're just not. They get queasy. You do see $1 billion verdicts in trade secret area, and so far on appeal, those have been winning on appeal. They're going through multiple layers of appeal, but there's not that same queasiness in other courts other than the Federal Circuit. So, in the damages climate at the Federal Circuit, I don't think is particularly good for patents. So I think that there's a lot of reasons why trade secrets, not the least of which now we have a federal law, right, Tim?
Yeah. And as we've thought a lot about this sort of macro environment from our own investors' perspective, it's like what's driving this, and is it real? And I definitely start at legislation, and not just in the U.S. So if you looked basically between 2016 with DTSA, the federal statute in the U.S., and 2016 in the EU directive to harmonize laws across the member states. You even look in China, in Japan, in sort of 1819, where they enhance their anti-unfair competition laws. And if you look at it again procedurally, of course, it's going to be different in bringing a case in the U.S. and Germany. But at the heart of it, the definition of what a trade secret is absolutely the same across all of these jurisdictions. It basically it borrows from all the original U.S. state law, and so I think that's pretty powerful for a lot of reasons, but not the least of which, and just kind of coming back to Ray and his sort of, I think, strong point of view, which couldn't agree more with. It's a patent and trade secret strategy. I mean, that is the best. And what comes out of all this like globalization of the law is this idea that I can actually, as let's say an American company, I can go file a trade secret misappropriation case under Japanese law. I don't need to have a Japanese patent, right? I just need to have, followed the, procedures and sort of met the standards. And if I'm doing things according to kind of a general process, I will. And same thing holds true. You're getting companies, and there's now a famous ITC case that Jim worked on, where these are foreign companies filing in the U.S. And so I think I can't probably stress enough about the sort of the global standardization of the law.
Yeah, further to your point there, good point, Tim. We go back just a little bit earlier, and the reason that ITC case between the two Korean auto battery companies could have happened is because the ITC and the Federal Circuit cooperated in the Chan Ray case back in 2011 to establish jurisdiction of the ITC for misappropriations that occur anywhere in the world but result in products being imported into the country that are tainted with the information. Let's also recognize around the same time we had the AIA, big change, because it removed best mode as an issue of invalidity as a practical matter, opening us up to be able to hold back valuable trade secret information related to a patent. We also had the prior inventor rights established across all technologies. Another big change that removed some of the anxiety that people had about deploying trade secret protection as a strategy. So these kinds of changes in the last 10 years have really made a huge difference in the landscape.
Yeah, and so too has the FTC's crusade against non-competes. And I guess maybe I'll just ask all of you about that. Ray, we could maybe start with you. How big an impact is that having?
I think it's having a dramatic impact because, everybody sees this sort of cliff if the FTC continues on the march where, non-competes are going to be non-existent, right? And then how do you then protect yourself from, an employee going from company A to company B and, taking all of that hard work in the same area? And Tim has a slide that I don't think he has it in this deck where, what's the easiest way to innovate? Steal it. Right. And it's a fairly on point presentation. So from my perspective, I think that's why you're seeing the rise. I also think with trade secrets at the ITC and through the DTSA, the nature of injunctive relief, getting immediate relief that's injunctive to stop, just to stop the hemorrhage. Whereas what you're seeing in patent law is more of a reasonable royalty analysis going immediately. And it's, in many scenarios, particularly in the life sciences, because of the public policy consideration, it's almost impossible to get an injunction.
Yeah,
no,
I agree. I agree with you, Ray. And, we're just last week, I had a debate with an official from the FTC about this program of theirs. And although I think it's nutty for a whole bunch of reasons, the fact is that by their doing this, they have really helped focus everybody's attention on what's the alternative. If you don't have any tools to address trade secret misappropriation other than going to court, well, it's pretty clear what is going to happen as a result of this. So everyone's paying a lot of attention to it, which is good in a sense.
I think it is good, and the old saying, you have far more at stake for loss from your own employees than you do from anybody, corporate espionage. And not to say it doesn't happen. And there's recently been a very high profile case of that here in Virginia, where I'm at, but usually it's your own employees. You know, either they're ignorantly giving it away, you know, having been scammed, or they're purposefully taking it and leaving. And purposely, maybe not with the same level of intent. Some of it, maybe they didn't know better, but
Yeah,
it doesn't change the fact that they took it.
In Gene, in the vast majority of cases, and this is through studies and experience, yes, the greatest source of loss is the workforce, is employees, but almost always it's because of misunderstanding or inadvertence. Like the sort of the venal planned theft is actually pretty unusual, and that highlights the need for active management, because obviously if you do more to help people understand what their role is in protecting this very important suite of assets, then they're going to behave more or less in accordance with that. If you put more effort into checking with them before they leave the company, they're not as likely to do stupid things.
Right. And if we move to this next slide, there's a couple really big numbers here. I mean, very big, the top two. And Appian is the one I was just referring to that happened in Virginia. And that was literally Pegasus had who they referred to on their own emails and internal documents as, quote, their spy at Appian. So in Virginia, I I've lived here long enough to get a sense of what goes on, and that $2 billion number, I think, is going to be pretty safe. I mean, the facts of that case are, and there's arguments to be made both ways, of course, right? But the facts of that case are pretty bad. And I don't see a Virginia court undoing that kind of number. I mean, I could be wrong, but and then in the battery case, it's 1.8 billion. I mean, you don't see these numbers in patent cases. I mean, you see them occasionally, but then they get reduced.
Yeah, well, just keep in mind, trade secret cases are really a morality play. It's fault-based, unlike patent cases, where it's just you could be infringing without any understanding or knowledge of what it is. In a trade secret case, if you're tagged for something, it's because you've behaved very badly. You've done something really dumb, at least, and sometimes venal. And so the juries will act accordingly. That shouldn't be a surprise to
anybody.
The
judges do too. The judges, they're people too, right?
They are too. Right.
So I want to blow past it. We could spend a lot of time on that slide, but I want to get to this slide because I think this is the cautionary tale, right, Tim?
Yeah. I mean, so we could have spent the whole rest of the time on the previous slide. So thanks, Gene, because I was
no problem.
You could see it. Look, I think as we tried to one of the things we've learned being in market is that who's paying attention to litigation data and to outcomes and to details. It's mostly litigators. Who's helping clients manage their their assets. It's not litigators, right? And so we've been using these cases as a way to kind of get across key points. In the first three cases there, I say lack of documentation, and as Jim will probably correct me, these are much more complex than a single thing of lack of documentation, but all three of them really sort of focus on this particularity issue, right? Like, you're not particular, you can't claim the whole manufacturing process. And so between Earth Solutions, which was a software case, Mallet, which is manufacturing, and this TRB, which is business method, they do represent good cases to understand where, man, a little bit of documentation would have won them the case probably, because certainly in the Mallet Bundy case, it was pretty bad behavior. But then also, and that comes back to one of Ray's earlier points, at the Olaplex L'Oreal case, ultimately L'Oreal found prior art, right? And so, we do have to kind of keep in mind that I can have this trade secret and I can have it perfectly buttoned up in private and done perfectly, but guess what? If I can find prior art, it's not a trade secret. So just remember that that's an important feature. And then other stuff, which is, again, no lack of bad agreements out there in the world, or no agreements, right? And so thinking that you have an implicit NDA, for instance, again, people lose cases for all of these different reasons.
An implicit NDA. Is that what I heard you say?
Yeah, so
that's a good one. I mean, that's a good one.
Yeah.
You can, if you convinced yourself you had an implicit NDA, you should not have a trade secret.
Well, you can sometimes have a really close relationship with a supplier.
It would have to be really, really close, though.
Trusted, right? And yeah, so it can happen. But I do want to emphasize something that Tim just pointed out here and about NDAs in the B2B space. The most frequent source of litigation disputes is poor NDA management, either in forming the thing to begin with, because people think it's a form, not a contract. It's a real contract with consequences, or in following up when it's all over and returning things where they're supposed to be. And that is one of the areas that, if you're looking at management of secrecy in a holistic sense, that companies will look at and avoid these kinds of problems.
Yeah, Ray, let's dive down that a little bit. I mean, because one of the things that's come up already in our conversation is some people don't like to have these things written down and particularized because, well, what if I leave something out? What if I don't? I think it's a far bigger problem that if you have systems in place, you're not following them, right? So like if you have in your agreement that you're going to collect these things after, the deal doesn't happen, then damn it, you better collect them, right?
Yeah, and if it's important to you, treat it as if it's important, right? So, mark it as an example, prioritize it. One of my big beefs with NDAs is, we get into an NDA and then people feel like they need to tell everything they know, right? Treat some things as sacrosanct.
Right.
I believe not only should you be memorializing, and I think you should be almost ranking it at some level. And I've heard all the litigators sort of say, well, if you rank something as top secret and it's actually something that was of general concern that was misappropriated, we're going to be put in a bad position. I hear you, and I respect that position, but I think not having it documented and protected and sort of embracing it when you hire people into the organization, tell them that trade secrets are important to you, make sure they see that in your action. And when they exit, oh, by the way, remind them that, during this whole process, this has been important.
And Ray, let me ask you a question. But when you're in your deals and there is this issue come up of trying to set priorities on what's most important and so forth, do you include caveats in the documentation about this is not meant to be comprehensive or scientific?
Absolutely. In fact, I mean, in the deals, what we've seen, and since we've adopted sort of a more rigid documentation program, the fact that we can identify in a privilege log a list of 37 trade secrets and then be color coded because one's of extreme importance and another is just cautionary. So red, green, and yellow as an example. I mean, it's people see that and they place value on it, and the question is asked and answered, and they move on, from the IP diligence questions to a more important question of the value of the company, instead of getting hung up on who's been exposed to what and what's leaking out the back door.
But you include something in your documentation of all of this happening that gives you some flexibility still later on in litigation. It turns out that one of these lower level things actually was very important.
That's right. Absolutely.
So I started my career as a litigator. So I say this with some love, but also with a lot of frustration. Litigators will always have done every job that every attorney could do better if they had done it themselves from the beginning, right?
Right.
The problem is hindsight is always 20/20, and there's a couple things that litigators often forget. And I always say this in the patent space. They tell patent prosecutors, oh, well, you can't do X, you can't do Y, and why would you ever done Z? And it's like, look, if I didn't do X, Y, and Z, you wouldn't have the patent to be litigating over right now, you know, and the same is largely true in the trade secret area. You know, if it's better to do something and have it be imperfect, because perfection cannot be achieved. And I think most judges understand that. Better to do something and have it be imperfect than to throw up your hands and say, well, we can't be perfect, so we're going to do nothing. Because I've had occasion in my career to argue in front of judges, you know, somebody from a defense perspective, because these trade secrets, so you sue somebody for trade secrets, they're immediately going to sue you for trade secrets. So it's always going back and forth both ways. I've said, just give me one example, just one example of anything you've done. Anything. It doesn't have to even be reasonable. Just one example of one thing that you've done to demonstrate that this was a secret, that you treated it valuable. You know, was it in a locked file cabinet? Was it anything? And surprisingly, the answer is they have nothing, not even one thing. So then the argument makes itself, Your Honor, if they can't even give me one thing, how could nothing be reasonable?
Right.
You know, and so go ahead, Jim.
Ray, you talked about a privilege on, speaking of litigation, when you refer to a privilege log, to me as a litigator, that means something else, but you're talking about using it in a transaction.
I am
what kind of a privilege log?
Yeah, in the transactional sense that I'm going to identify trade secret records in a way that you can share those, but it's not going to reveal the trade secret. So I'm not giving a catalog of my trade secrets, but you basically know what I'm talking about when I identify that as in that log format.
And that kind of pivots us very nicely into this slide here, Tim, about, you know, what is the trade secret? Who has access? Have you actually documented? Do you know what's going on? I mean, because this starts to get us, you know, wrap all of this stuff together. You want to tell us what we're looking at here?
Yeah, I mean, look, this is, I use the word architecture, and, you know, my, computer engineering friends tell me it's not architecture, but I like to sort of think in these kind of models for, okay, what are we trying to build at Tangibly? What have we built? It's this really sort of three-pronged approach of trade secret management. In my mind, is it's an asset, it's an identity, and it's a contract, right? And you can have the asset really well buttoned up. You can know who has access to it. But if the contract's expired or the contract is poorly, written, it's meaningless, right? So it's really those kind of three pillars. And then really like this idea of the two best practices are, if someone has access to the trade secret, just tell them it's a trade secret. Be very explicit. They already have it, right? And so we built a workflow to do that. And then training. I think, Ray and Jim both mentioned, it's like, this is the highest ROI when it comes to trade secrets is training, 100%. And as Jim pointed out, lots and lots of misappropriation cases are on the back of situations where, the employees had no idea, right? They literally didn't have any idea. So, train them up. And we're finding from our customers that the training has just been super well received. Make it simple and quick. Get people using the term trade secret, understanding what it means, how it relates to the business. So that's Tangibly in a nutshell.
Okay. Do you want to say, or I mean, one of the things I think that you guys do that's really, really exciting is the patent analysis. Do you want to just quickly mention what that is? I'm seeing who's here on the webinar, and I know we have some patent people here who I think they'll find that particularly exciting.
Awesome. And certainly Ray can chime in because he's been a user since our first sort of alpha version. So we've built this product called Patent X-Ray. And actually we're going to launch a sort of a freemium version of it in the next couple of weeks. And so if anybody wants to know more, just kind of reach out. But so basically we've built an AI model to go analyze patents and predict the underlying trade secrets that are sort of just below the surface. And so, the easiest example is, when the model sees a temperature range, it'll grab that and say, well, the precise temperature at which you're running the XYZ process is probably a trade secret. So the model outputs, organizes sort of these buckets of trade secret candidates, basically. And what we found is, whether you're the person that wrote the patent or the person that invented the thing or the team, as you look at the results of the patent X-ray, you very quickly go, oh yeah, that's right. Those are trade secrets. So it's really been meant for a tool to kind of help guide you to where you should be looking.
So I see, Ray, and I'd like to get your comments on it, but I see like two obvious uses for it. One is making sure that what the AI thinks is a trade secret, you go through and there's a checklist for you. Is it or isn't it? And if it is, have we done enough to and then two is like, well, gee, that's a great insight. Maybe we ought to be filing a patent application on that, or maybe we should have included that, because without that, maybe it's not 112 supported. I mean, I see a lot of uses for the X-ray.
Oh yeah, I've been excited about it. I mean, ever since Tim introduced it, you think about it from, initially just sort of the enablement component, right?
Absolutely.
What's missing in this application, and do you need to have it there, right? From an enablement perspective. You've also got clients who will tell you, we don't have any trade secrets. You run X-ray, and then all of a sudden they're like, wait a second, maybe we do. That is right. And then one I've been particularly excited about is the concept of using this on competitors and looking at what they're intentionally keeping out of their application. And maybe we'll focus some attention on that, right? So I see a lot of opportunities for this AI-based X-ray. I'm excited about it.
Yeah, I think it is. And I know we didn't really tee that up for this particular webinar, but as I was learning about that and what you're doing and everything, I just want to and also seeing how many patent people are here in the chat and asking questions. I mean, definitely look into that. That I think is going to be something that everybody's going to want to at least kick the tires on. We've got a number of questions here. Let me see. We have I suppose we've got some more. We could spend all day talking about this, but we got a couple questions I specifically want to get to here in the chat. One is from Dean. He asks, how do courts differentiate between the quote general knowledge end quote of a departing employee and a protectable trade secret? With non-competes falling out of favor, is trade secret litigation expected to rise? Jim, I'll go to you on that first.
Yeah, I mean, taking the second question first, I think the answer is yes, because like I said earlier, you really don't have any other alternatives if those tools are taken away. And the first question was?
And the first question is, how do courts differentiate between what is general knowledge and a trade secret?
Yeah, and this is a little bit of smoke and mirrors. Sometimes it's a judgment call on the court's part, but if it's the kind of thing that we feel represents increased skill, like if you take a software engineer, and at the beginning they produce things that are not very efficient, and over time they learn to write code very efficiently. That skill set is theirs to take with them. But if it's something very specific, if they've developed an algorithm for their employer, then that can be claimed as a trade secret. And so the courts look at, well, let's understand exactly what it is. If it's really specific, then we can hold it up and compare it to what's in the public domain or what can be articulated as skill. So they're usually pretty good at making the distinction.
Ray, thoughts on that?
Yeah, no, the same. I mean, from my perspective, it's the concept of, begins with the articulation of what it is that you believe is your trade secret, right? So you make sure the employee knows that when they come in. You know how it's been modified since they've been there. You make sure they know that when they leave, and it becomes a much easier dichotomy between what was general knowledge and what they're entitled to leave with, and what was a trade secret.
Yeah. So Tim, anything to say there? Any thoughts there?
No, I mean, it's a great question. We get it all the time, and I think it absolutely starts with, well, if you don't define it, you may as well they're going to consider it general working knowledge, right? And so that's kind of the rub. Yeah, definition.
Okay, so the next question we have from Jason, he asked a couple questions. I'm going to kind of synthesize them together, and then maybe I'll follow up with some more of his context here. He asked, like, what are, and he's from a company, and they handle their trade secrets properly, you know, so it's not like doing nothing. But he's like, what are your 3 best suggestions on reasonable steps that everybody should be doing, you know, to enhance what they may already be doing themselves? Are there such, or is it context driven, or do you have a favorite 3, Jim, or a favorite one?
I think if we're doing this in 3s, the best way to think about it is the employee life cycle. When they're coming in, when you have them there, and then when they leave.
Mm-hmm.
So when they're coming in, you do smart onboarding and recruiting. When they're there, you train them like Tim was talking about. And on their way out, you use the exit interview not as the HR typical questions about what could we have done to make you happier here. You use it as a moment of risk assessment to find out where this person is going, what they're going to be doing, and what conversations need to be had in order to reduce the risk that they're going to do something untoward.
Okay. Ray, do you have a favorite 1, 2, 3 things?
Yeah, I mean, from my perspective, it's flavors of that, but it's routine education and reminding people about this concept, and it should be a part of all of the employment training that goes on. The second would be to capture, and the third would be to docket and revisit. Right, sort of make sure that you don't just capture it and put it in a stale bucket someplace. If it's important to you, you got to figure out what's happening to that trade secret, whether CDAs need to be attached to it, who's being exposed to it, where those people have went. So it's, you know, from my perspective, it's that routine education, it's capture, and it's revisiting those trade secrets from time to time.
Okay, great. And so then the follow-up here then becomes, he says, cyber protections, access controls, confidentiality training, NDA, good culture. How important are those things? And maybe where would you put your emphasis if you needed to?
Yeah, I'd say on culture. From my perspective, that's what we try to do more and more is, you know, create a culture that intellectual capital is important, should be respected, treated as a trade secret, patent it, manage it. So,
yeah, there's a sort of necessary and sufficient condition. We all have to protect against hacking and so forth. And so the strength of the protection in cyber is very important, but that's not where the difference lies. The difference lies in active management of relationships, mostly with the workforce, and secondly, with others that you have to share your information with.
Yeah, because I think you mentioned this during the webinar, but if not, you would mention it, Jim, during when we were in the green room getting ready. It's not that malicious behavior doesn't happen in misappropriation cases, because it does. But often your biggest risk is the employee who either ignorantly, because they haven't been informed or they don't know, or intentionally they're leaving and they're going to do something. So it's your workforce that really needs to be taken into the biggest account. So you got to have hacking protocols and access controls, but your employees are going to really hurt you here.
As I've often told people, you know, the one thing, having done hundreds of these things over the years, the one common theme I find is that somebody did something dumb.
yeah.
And so what this suggests to us is,
Yeah.
you know, proactive management can really, really reduce the risk of loss and improve your ability to maintain control over these assets.
Yeah. So gentlemen, we're at the top of the hour. We could talk about this all day. And actually, IPWatchdog, in coordination with Jim has agreed to help me do this next year. We're going to have a trade secret program, and we're going to dive into these things over a couple days. So look forward to that. I believe we have that on our calendar for April of next year. We'll probably do some more of these webinars leading up to it. And I know we got a ton of questions in the chat. We got a ton of questions in the Q&A. We'll share that with the panel, and you'll get follow-up. And I did notice somebody wanted to hear more about what Tangibly is doing, so we'll make sure that we pass that along to Tim, and Tim will follow up with you specifically on that. But gentlemen, your final thought here, if there's one thing that you hope everybody leaves today remembering, what is that one thing? Jim, I'll start with you, then Ray, and I'll give Tim the last word.
Okay, it's that point that I just made. Active management matters, and it doesn't take much effort to improve your risk environment enormously.
Great. Thanks a lot, Jim. Ray.
Yeah, my three are, education, awareness, and documentation. That's what I want people to remember, is to really focus on that when they're dealing with their employees, and respect, have employees respect and take pride in the intellectual capital that's built in an organization.
Yeah, great. Awesome. Thanks, Ray. Really appreciate you being here. And last but certainly not least, Tim, your final thought.
I'm going to keep it really simple, Gene. Do something.
Yeah, do anything.
Just do it.
Do something. I mean, because and I'll just give you my thought. And if you do something, it fits into everything we've talked about. It fits into, you're doing something, how important it is. It gives you the ability to identify what it is that they should not be telling others, and how to treat it and that sort of thing. But if you don't document it, if you don't know it exists in the first place, you can't do anything to protect, whether or not what you're going to argue in litigation, you can convince a judge that it was reasonable or not. Save that. I mean, the whole goal of this is not to get to litigation, right? And if you do get to litigation, then you got to act quickly. And that was another conversation for another day. But you don't want to get there. You want your people to be well informed. You want the culture to be in place. You want agreements to be in place. And you can't just do it once. You got to do it and remind them that you reminded them. And that's where you get the good culture. I think that's my final thought. So, gentlemen, thank you so much. Great conversation.
Yep. Thank you.
Thank you.
Gene.
Thanks, Gene.
Thank you all for
Thanks,
joining
Jim,
us here
Ray.
today. We look forward to having you join
Thanks,
us again
everyone.
in the future, but that's all we have. So bye for now, everybody.
See you guys.